This is The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. In this program, we provide information and resources that will help you decide perhaps whether or not you can handle some issues yourself, and some you certainly can. Perhaps we'll even help you decide that if you do need outside counsel, you'll be better prepared, and so will the professionals that you decide to hire. Either way, you're in a better position to save time, save money, and hopefully achieve better results. We thank the Bazar Law Firm in East Providence for their continuing support to provide information and insights on the various topics that we'll tackle. And Attorney Jacqueline Grasso and David Bazar comprise that team. With us today, David Bazar again.
Hi, Deb.
Hi. So let's pick up where we left off, and last time we were talking a little bit about divorce. So today, divorce part 2, the nitty-gritty, better known as the money and the stuff. So who gets the antique clock, Fido, the stocks? Who gets the debt? How do you decide what's fair, and how do you get to that place? And how do you avoid some of those very costly mistakes? We figured that it would be a good idea when we started to talk about divorce, we'd go through the beginning to end. And David last time pointed out very conscientiously and carefully that it was about the children. So today we're going to get into the nitty-gritty. So, David, I understand whether it's Rhode Island or Mass, are they both no-fault divorce states?
Well, those are grounds for divorce, and it can be. So back in, I guess we're going to call it the old days again,
okay.
The only way you could get divorced was for fault. Somebody had to be in the wrong for something, and there were a lot of different grounds that you could file under. Adultery was a grounds for divorce. Continued and habitual drunkenness was a grounds for divorce.
My goodness.
And on. Lack of support, desertion, I guess we would have called that back in the day. So, in fact, many of those grounds still exist. But what they did with the liberalization of the divorce laws was they created the no-fault ground. In Rhode Island, irreconcilable differences, which of course the irremediable breakdown of the marriage. We don't get along for whatever reason anymore. There's no chance of reconciliation. It's a marriage in name only. The marriage is over. Irretrievable breakdown of the marriage in Massachusetts, same thing. So we call it a no-fault divorce because you don't have to prove one or the other's at fault, just that the marriage can't continue any longer. Okay,
so while we're going to talk about money today, if there is fault and someone finds that there is, someone did something that makes the other person, makes them guilty or guilty of unsavory acts, whatever that means, does that impact on the financial side of life?
So you're talking about the somebody done somebody wrong song?
Okay.
Okay. So the ground doesn't matter.
Okay.
But the conduct does. Okay. And in the equitable distribution statute, there's a number of factors that the court is supposed to look at in determining how to divide up property. So one of the factors is conduct. And in fact, it's conduct both good and bad of the parties. Okay. And if you decide that, if you as the lawyer, if you're working with someone, if you decide or you hear that someone who is going to be divorced was on the wrong side of it, does that affect your judgment as you sit down with, let's figure out how we're going to divvy up the goods? Okay. So how we divide up the goods, as I was saying, is based on the equitable distribution statute. Mm-hmm. And so the way that statute works, and it's another interesting development in the history of divorce, is prior to the development of the equitable distribution statute, which is the statute that talks about division of property, it was very interesting. Everything belonged to the husband, in some states really, including the wife. So the husband really owned everything, and when they got divorced, the husband owned everything, and therefore the wife would get alimony, permanent alimony, and the obligation to support your former spouse ad infinitum was part and parcel of the fact that she didn't have any assets, according to the law back then. And so as the divorce laws again became liberalized and equitable distribution came into play in many states, and some states have what they call community property states, and Rhode Island and I believe Massachusetts as well uses this equitable distribution statute. It talks about property that is marital property and how you divide that up. So the first thing you really have to do to divide up marital property is determine what is marital property.
Okay, let's go with that for a moment, because in first marriages, perhaps both came with nothing, or maybe they did. Maybe the parents of one had offered not a dowry, but offered them property. Is that a marital asset if she brings it or he brings it? How do they deal with that?
So in Rhode Island, any property that you had prior to the marriage is separate property. Any property you acquire by gift or inheritance is separate property, and that property doesn't even go into the pot as you determine what you're going to divide up as marital property for equitable distribution purposes. So, for example, if a husband's parents gave him a business, a family business, didn't pay for it, he just acquired it by gift, or if they left it to him by inheritance, that doesn't go into the marital pot for division. However, the income that it produces can be considered for certain things, and of course, as we get down the road, alimony will be discussed. But the ownership of that business that was gifted to him theoretically is not part of the equitable distribution pot.
So just as people, not to get off the subject, but just as people have prenups before they get married, once they get married, sometimes the character of whatever that was is changed. So if the boy's parents gave them something, but now the new entity, the married couple, start putting money into it, whatever it is, then she has some stake in what was. Does that entirely sully the waters or make it very difficult, or what happens?
It's actually a very, very good point. And in Rhode Island, there's a case, I think it's called Quinn versus Quinn, talks about transmutation of property. So we have that property that you acquired either before the marriage or by gift or inheritance, which would otherwise be separate property, but now you've sort of introduced it into the marital pot. For example, let's take a home that you received, a vacation house by inheritance, and you've put your spouse's name on it. That now becomes marital property. Or you'd have money that you inherited and you put it into a joint account. That becomes marital. Or you take some of the property, personal property, and you put it in the home. And that is now marital property because you both get use and enjoyment out of it. So the court can make the determination that what was once separate property has become marital property.
And so when someone sits down with you and you're going to represent them, after you've gone through the initial paperwork, filings, as we talked about before, how do you get them to begin to approach the division of that assets? How do you get that? Do you make them make lists? What's the process, David?
Okay. So the first step, as we're just talking about, and I know I maybe dragged this out a little bit on you, is let's determine what is in the pot. So many times the biggest assets we're looking at are the home, if they own a home, the retirement assets, if they've acquired retirement assets during the marriage. And again, you can have some that was prior to the marriage and some during the marriage. So the first thing we need to do is figure out everything that goes into the marital pot. And then usually we start at a 50-50 division of those assets, because it's an equitable distribution state. Equitable doesn't mean 50-50, but based on all other factors as you look at them. And what are those factors? The length of the marriage, the contribution of each party towards the acquisition of property, the contribution of the party as a homemaker, taking care of the children in the home, the contribution of the parties to maintaining and preserving assets, conduct of the parties as we talked about. So that could be, did someone gamble away property? Did somebody have an adulterous relationship? Those types of things can be factored in. Once you factor in what all the property is and what the conduct and the other issues into the property are, you may go from a 50-50 split to a 60-40 split, perhaps, depending on the conduct, and those types of things. You may also, as you're trying to parcel out what the assets are, and with an eye towards alimony or other things that may come down, want to move some of the property to one spouse or the other. And I'll give you an example of that. Let's suppose we have a situation where we have a husband who doesn't make any money, but the wife makes a lot of money. Sort of reverse that on you for a lot of people's thinking. But they also own a lot of property in real estate, income-producing property. So you might want to take some of that income-producing property and put it in the husband's column, so that down the road when we look at the, because you do alimony after you do equitable distribution to see what the need is for alimony, if any, and we'll talk about the history of alimony. But if you take the income-producing properties from the pot and put them in the husband's column, and then offset those with other assets that maybe the marital domicile, something like that, now the husband has income that can be produced out of that. And the amount of alimony, if any, may be lessened by doing it that way. So first of all, we need to look at what the nature of the assets are, and then what's the best way to divide them.
Sounds like we can almost have another separate conversation with an actuarial or a financial planner. But back to something you mentioned at the outset there. Suppose you have a stay-at-home husband, stay-at-home wife. When you're looking at starting out at 50-50, for those who might have been on that side of the fence, being the stay-at-home, not working outside the home, bringing in an income, does the law look at that as a 50-50 partnership because that person stayed home, took care of the house and the children, if there is, or if there's a dog? Do they look at that as having equal weight, along with the idea that someone was outside the home earning an income?
Absolutely. And it's written right into the statute, the contributions of either party as a homemaker, as the person who did stay at home and take care of the home and create the home and take care of the children if there are any, or the dog, as you say. So absolutely, that is a factor just as strong as the factor of the person who went out and made the money and did the work and all of that, because each of those are necessary to create the marriage and the home. And so they're both equally weighted factors.
Good to know. And while I want to continue talking about the money and also focusing on what's fair, how about the very peculiar things like that antique clock that you can't divide down the middle, or Fido, because Fido is precious to both and you can't cut that? How do you deal with that?
Two things on that. Well, first of all, the lawyers generally do not want to have to get involved in the division of the pots and pans, as they say.
Yes.
But if you have some valuable collections and antiques or other items that are of more value. I mean, we didn't talk about there could be boats and cars and those types of things, and sure, those all go in the pot. Usually what happens is the parties can work those things out because that antique clock was something that was really special to the one or the other. And so the one spouse really, that was mine, not the sense that the ownership's mine, but that was meaningful to me. I went out, I found that, I bought that because I loved that. The other spouse really doesn't care, but it's a really, really valuable antique clock, almost in the same value as the other party's boat. Well, we'll put the boat in your column, the antique clock in the other column, and we'll try to balance those as we go down. And that's what you're trying to do, is be fair, not only on the value of the assets you're dividing, but who is it really meaningful to as you divide them, and who gets more use out of them.
So I understand among your skill set, you certainly can make a list of the dollar and cent value of something. But are you also involved with, I don't want to say counseling, because it's not like marriage counseling if there's a divorce that's imminent, but refereeing or trying to decompress what can become heated just because someone might get vested in a single, I don't know, piece of jewelry or whatever, and then suddenly not think clearly about the dollars and cents, but just wants to become, I don't know, belligerent for the sake of argument.
Or vindictive.
Or vindictive,
yeah,
or whatever.
Sure. That happens a lot. And sometimes you try to as a mediator, I would try to talk people through what is it really that's motivating you here, and how can we get past this, and what can we do. If it's a dollar and cent thing, usually that's really easy. Well, I really like that, but I know she really likes that, and so maybe we can figure out a way to put that into the column it belongs in and offset it with something on the other column. It's a give and take thing, and you try to get past the vindictiveness, past the I just want to really tick the other person off unnecessarily. Dividing up dollars and cents is really easy because you can do that. Dividing up the dog, as you said, that's not so easy sometimes. And frankly, under the law, a dog is personal property. It's got some value, maybe. Maybe it costs more than it's worth. Who knows? It depends on whether you're a dog lover or not. But certainly, I've had cases where we've almost had as much issue with dividing up the dog and the cat, or the cat and the dog, as we do with the children.
Sure.
And maybe we have to have a shared custody situation.
Even with a dog?
Well, maybe.
Could it happen?
It could happen,
really?
But usually those things work themselves out. And as we were talking about the money, and we had mentioned earlier, the retirement asset, which usually is one of the bigger assets these days in a marriage. You have to be careful when you divide these things up, and really there's some people who have a certain expertise in what we call qualified domestic relations orders. And those are a way of dividing that asset up so that there's no tax consequence as you divide someone's either pension plan or 401k or whatever it might be. And you can do that in such a way that if there is a premarital portion, that can get cut out so that just the marital portion is divided.
Okay, so if we're back on making a list of what those assets are, you try to stay out of the division of the pots and pans, but you do need to make sure that it's fair, because if it gets in front of the judge or something and it's clearly not, it's not going to work. Do you help counsel your clients in what to and how to either barter something, or whether they should perhaps sell something and then divide it versus keep it? Do you counsel them with that? Because sometimes those things aren't as clear, or maybe someone might not be as well informed about the true nature or consequences of an asset. Do you deal with that? Yeah,
and we have to, and of course we do. So again, usually it's best that the parties sit down and work out those types of things between themselves with the two lawyers that might be involved. A fallback position for the court or for anyone else on any asset can be to sell it if the parties can't agree on the division of it. Even a house or real estate. And you don't want to have to get there, but the court can appoint someone who they would call a commissioner, who comes in, takes control of the asset, puts it up for sale. So now you're paying the commissioner a fee to sell it. You're paying the brokers usually that are hired the real estate brokerage fee to sell it, and the parties will split whatever's left after that. That's when one party really won't cooperate, or both parties won't cooperate with each other to either decide who's going to get a piece of property or sell it, and who's going to be in charge of the sale. When you get to that point in time, the court will step in and take over and make sure it gets done.
Okay, address, if you will, for a moment. We're starting to talk about assets. What about the other side? How do you divvy up the debt? Because, well, how do you actually deal with a client when they come in? Do you tell them right away, put a freeze on every bank account, cancel all your credit cards? How do you guide them through this process? Because that can become a problem eventually, even if it isn't the day they walk in.
Right. So once a lawsuit or divorce is filed, there are automatic orders that say you have to keep the status quo on everything, which means you can't go out now and just sell things because you want to raise money, or give things away because you don't want them as part of the marital part, or do anything of that nature that affects what you normally do. You can't take a spouse off of health insurance because, well, we're going to get divorced, I don't want him or her on my health insurance anymore. All of these types of things. So long and short on that is I tell my clients to make sure they protect themselves, but I don't tell them to do things that would, in essence, violate those automatic orders. However, someone comes in and there's $25,000 or $30,000 in a savings account, and they're afraid their spouse is going to take that, I would tell them, take half, leave half, put it in an account. Your spouse is entitled to the other half, but don't do anything with it. Don't give it away. Don't spend it. Just keep it so that it's there and can be accounted for, and you've at least protected yourself in that aspect. Now, in terms of what we do in determining at the beginning what the assets are, each court in Rhode Island and Mass has a form. It's a financial form. In Rhode Island, it's a DR6. And what that form is, it's a listing of all the assets and liabilities that you have, as well as your income and expenses. So that form gets filled out as carefully as you can, which will give the lawyer an initial look into what there is. We might want the tax returns to go through and make sure there's nothing missing and things like that. But the answer to the question about what do we do about debt, it's, to me, handled the same way that the assets are handled. Oftentimes today I find that people sort of keep their own debt. I have my own credit cards, my wife has her own credit cards perhaps, and people often come in and say, I'll pay mine, she can pay hers. If that's the case, and they're equal or they've been used for things that you're keeping, that often happens. If you're keeping a car with a loan, usually you'll keep the loan that goes with the car. If you're keeping the marital domicile with the mortgage, oftentimes you'll be responsible for the mortgage. So the debt can get divided up either with the assets that were purchased in connection with the debt, or if it's college loans or something, you might have to divide that equally, depending on how it was incurred.
How about on the rare occasion, I'm sure, where someone is less than honest? Now, you assume that everyone is going to keep things status quo. How about the person who has a pension at his or her office and they know they're about to be divorced? The other person doesn't know that the employed person goes to talk to HR and say, let's just defer that, for example, does something that's dishonest. Yeah. Let's not give me that raise until, let's not give me that bump in the contribution until. How do you ferret that out? How do you even know how to anticipate that? What do you do with that, David?
Well, there are a lot of different ways that people can be less than honest in these type of situations. Some things are very easy to deal with, other things are more difficult. I could tell you there have probably been cases where there's hundreds of thousands of dollars and one party or the other decides, I'm going to try to move some of that out, either by gifting it to people or doing other things to try to move it. Well, we can usually find that. And so when you have a case like that, it's my position that, for instance, let's just suppose that there's a couple that's married and there's older children, and one or other, the husband or wife aren't really involved with the children, but the other one is, and that one who is starts putting money into their names, thinking that he or she is going to hide that from the other spouse. My position is, you gave it away, that was your choice, that comes out of your column. So if you want to give away, $1 million out of the $5 million that we have, thinking that the kids are going to give it back to you once the divorce is done, as far as I'm concerned, you made that gift. That's on you. So put the $1 million that you gave away in your column. Now, we can do discovery. So I've had cases, to address a little bit of what you're saying, where all of a sudden the husband's income, say, has taken a precipitous drop from the year before. What's that all about? Well, I'm not getting, I'm a truck driver, long-haul truck driver. I'm not getting the calls I used to get. Well, we can subpoena the employer in and ask questions. How are these assigned? Can you not take them, or do you have control over those? Oh, you have control over those, and you've been turning down longer routes because you don't want to drive them. Well, now we know. And so that might factor into child support, which I think we talked about last time, or alimony and that type of thing. And the court is allowed to see past what's actually happening to what should be happening.
And that would happen if it goes to a trial, or that would happen just...
It can happen short of a trial, in discovery.
Okay. And not always would you need a forensic accountant or whatever to go through that, but is that an avenue that's available if you become suspicious or somebody becomes suspicious?
When you have people who have assets that are in all different places and it looks like it's moving from one place to another, you might want to bring in a forensic accountant in to say, well, let me follow the money and see what's there and what's missing and where it should be.
And without having a financial analyst here, are you able to, or most lawyers able to deal with the list of assets as they're presented and give the client some tutorial about, do you understand that this value of this house is beyond its value? As you pointed out earlier, it's an income-bearing property. It has more value to you if you keep it versus you should get rid of it. Are you able to give them counsel about that, and even if they don't know to ask?
Yeah, and so certainly where there's a lot of money involved in investment assets and houses and those types of things, you might want to bring in a financial advisor. They probably already have one, and the financial advisor may want to be part of the process of dividing up assets and stuff. We, as lawyers, do know and can counsel on a lot of that, but there's other issues that go into some of the tax things, so accountants and financial planners may be very important as part of the process.
I don't want to say that people want to do divorce on the cheap, but obviously they like to keep expenses down. And while I know you and Jackie are both mediators, and we're not talking about mediation, does it save anybody money? Does it save the divorcing parties money if they were just to mediate it versus going through all of this?
It can. Mediation can be very helpful. I will tell you honestly, the thing that will save people the most money is if they act reasonably and don't create problems where there aren't any, and think about what's in their best interest and their children's best interest and the other party's best interest, and try to work things out. That usually will be the best way to save money.
So is it more likely to be a mediator or you who's apt to sit them down and say, let's decompress this, let's defuse this a little bit so that we can get to something that's reasonable? Because that would be one mediator with two people versus one lawyer, one person, one lawyer, one person.
A good lawyer or a good mediator will both do that.
They will both.
So we have one more thing to finish before we finish. So let's just suppose we've divided up all the assets, and we know what the husband's going to have and what the wife's going to have, or one spouse or the other spouse. We still have the issue of alimony. So let's just talk a little bit maybe about how alimony developed, because remember we started with the husband got all the assets and the wife got the alimony. So somewhere along the line we moved away from permanent alimony to rehabilitative alimony. Alimony that was designed to take, if it was the husband who was home, the homemaker, and get that person back into the workforce, or the wife back into the workforce. In Rhode Island, we're looking at a 3 to 5 year rehabilitative period for the most part. There are times, again, you look at the age, the ability to support yourself, the ability of the other party to pay, and the education, and all of those factors, health, and put all of those in, and then the court will determine what length of alimony is necessary and or is permanent alimony necessary. So I had that case I actually was mentioning to you earlier about the person who had the long-term truck driving job and long-haul job. And the wife had serious medical conditions and couldn't work. And I told him, although Rhode Island has gone towards rehabilitative alimony, there are those cases where permanent alimony could be in play. And so I said, give her the house and give her some rehabilitative alimony. He didn't want to do that, and he left, went to another lawyer, and that lawyer ended up in the Supreme Court, where the court confirmed that there is still in Rhode Island permanent alimony in the right situation. Massachusetts has a statute that addresses alimony, and it's quite comprehensive, and in long-term marriages in certain circumstances there will be alimony permanently.
Good to know. I understand that the issue about alimony is a moving target right now, and it's often in the news. Well, thank you, David. We appreciate your tuning in. Our discussion of the law matters continues. Stay tuned, because it matters to you. Thank you.